Welcome to The Explainer. Today, we're stepping into the incredibly dense, but honestly absolutely fascinating world of Philippine civil law. Specifically, we're going to look at the legal framework surrounding everyday wrongs, accidents, and liabilities. It's kind of like a universe where your everyday actions are put under a legal microscope.
Think about it for a second. Have you ever been wronged? Maybe a neighbor's dog completely ruined your garden, or a careless driver clipped your side mirror, but you just didn't know if you actually had the legal grounds to sue. Or hey, maybe you were the one who made a mistake and suddenly wondered if you were about to lose your entire life savings. Well, today we're figuring out exactly what constitutes a legal wrong under Philippine law, and more importantly, who actually foots the bill.
Okay, let's dive into this. Here's our roadmap for today. First, understanding torts and wrongs. Second, who foots the bill. Third, the chain of blame. Fourth, escaping legal liability. Fifth, public and private nuisances. And finally, number 6, medical negligence and malpractice. So, starting us off with Section 1, understanding torts and wrongs. Before we can even talk about lawsuits or damages, we really have to identify the underlying act that creates legal trouble in the first place, right? And it all begins with Article 19 of the Civil Code. Read this quote with me. Every person must, in the exercise of his rights and in the performance of his duties, act with justice, give everyone his due, and observe honesty and good faith. Now, this is the doctrine of abuse of right. It's literally the moral and legal bedrock of our entire explainer today. It basically says that even if you have a legal right to do something, if you exercise that right in bad faith, with the sole intent to prejudice or injure someone else, you're committing a legal wrong. You absolutely cannot weaponize your rights.
Now, when those rights are weaponized, or honestly, when we just mess up, we enter the territory of torts. And there are 3 main classes here. First up, intentional torts. This is deliberate harm, just like that abuse of right we just talked about. Second is negligent torts, or culpa acquiliana. This one's actually the most common. It's when harm is caused simply because someone failed to observe the required diligence. It's a mistake, sure, but a legally actionable one. And third, strict liability. Now, this is fascinating because it means you're liable regardless of fault or intent. Like if you own a wild animal and it bites someone, or if you manufacture a defective product, you are on the hook, period. No excuses.
And while we're defining our terms, we definitely have to look at this concept, acción in rem verso. It's a bit of a mouthful, but this Latin phrase basically refers to an action to recover something paid without just cause. It's the whole core of unjust enrichment. Think about it. If someone gets rich at your expense without a valid legal reason, say a bank accidentally deposits 1,000,000 pesos into your account, well, the law says you have to return it. You can't just unjustly enrich yourself just because a mistake was made. Bummer, I know.
Okay, moving on to Section 2, who foots the bill.
Now, what's really interesting about this slide is that the person who actually committed the act isn't always the only one paying for it. Under the concept of vicarious liability in Article 2180, the law literally imputes negligence onto supervisors or employers. So parents are liable for their minor children, employers are liable for their employees. Teachers in schools? Yep, liable for their students. And why is that? Well, because the law presumes that if the dependent messed up, the supervisor was negligent in their selection or supervision. Now, it's a rebuttable presumption, but the liability is direct and solidary. That means the victim can completely bypass the employee and sue the employer directly. Wild, right? Actually, even the state can be sued, but only if it was acting through a special agent. And if multiple people cause the harm together, they act as joint tortfeasors, basically sharing all that solidary liability.
Right, let's look at Section 3, the chain of blame.
So we know who did it, and we know who's paying, but how do we legally connect the negligent act directly to the injury suffered? We do this through the legal magic of proximate cause. The absolutely crucial point here is that a court won't just look at the very last thing that happened before an injury. Nope, they look for the proximate cause. That's the act that, in a natural and continuous sequence, unbroken by any efficient intervening cause, actually produces the injury. Think of it like a rapid, unbroken chain of events. A prudent person must have been able to foresee the harm. But if an entirely independent, completely unforeseeable act jumps in and breaks that chain, what we call an efficient intervening cause, well, that actually shields the original tortfeasor from liability.
To really wrap our heads around causation, we have to distinguish between a cause and a condition. And guys, this is a vital nuance. A cause is the active force that produces the injury. A condition, on the other hand, merely creates the environment for it to happen. Let's say you legally park your car on the street, and someone texting on their phone swerves and hits it. Your parked car was merely a condition. The active force, the actual proximate cause, was the driver texting. So generally speaking, someone who merely creates a condition is not legally liable.
Moving right along to Section 4, escaping legal liability.
But wait, what if you are the active force? Are you just doomed? Well, not necessarily. We have to start with what is honestly one of the most ironic and fascinating concepts in civil law, damnum abscit injuria. This translates to damage without legal injury. It's the completely surprising fact that someone can absolutely ruin you financially and you get absolutely nothing in court. How is that possible? Well, because if a person is perfectly and legally exercising their rights, without bad faith or intent to injure, and it just so happens to cause you harm, there is technically no legal wrong. Imagine opening a legitimate coffee shop right next to a competitor, offering way better coffee at half the price and driving them completely out of business. They suffered massive damage for sure, but because you were just exercising your legal right to do business, it's damnum abscit injuria.
Now, if that doesn't apply, defendants have a rapid-fire list of other defenses they can use. There's due diligence, basically proving you acted like a good father of a family. Then there's fortuitous event, like an act of God, say a sudden typhoon was the sole cause. Assumption of risk means the victim voluntarily accepted the danger. We also have the last clear chance doctrine, which is exactly what it sounds like, where the plaintiff had the final opportunity to avoid the accident but failed to do so. Then we've got waivers and the rule against double recovery, which prevents victims from getting compensated twice for the exact same injury. But listen, prescription is a huge one to remember here. An action upon a quasi-delict expires or prescribes after exactly 4 years from the day it was committed. If you wait too long, your right to sue completely vanishes. Poof.
Okay, let's look at Section 5, public and private nuisances. Let's slow the pace down just a bit and pivot to a highly relatable everyday issue. This is where the law steps right into neighborhood disputes. The legal definition of a nuisance is super broad. It's any act or condition that injures health, offends the senses, shocks morality, or even obstructs free passage. And nuisances are classified in two ways. First, there are nuisances per se. These are things that are a nuisance at all times and under literally any circumstances. Think of a rabid, mad dog running loose. Always a nuisance. Then, there are nuisances per accidents. These are nuisances only because of their specific location or circumstances. Like, a slaughterhouse is perfectly legal, right? But if you build one smack in the middle of a quiet residential zone, it instantly becomes a nuisance per accidents.
Now, the legal boundaries of exactly who is affected are crucial here. A public nuisance affects a whole community, a neighborhood, or a really considerable number of persons. Think of a factory dumping toxic smoke over an entire town. A private nuisance, on the other hand, affects only a specific person or maybe just a few people, like your next-door neighbor deciding to play a drum set at 3 a.m. The legal remedy and exactly who can file the complaint changes entirely depending on whether it's the general public being annoyed or just one unfortunate neighbor.
And that brings us to our final section, number 6, medical negligence and malpractice. So let's move to our last highly specific scenario. This is what happens when healthcare providers, the people we literally trust with our lives, fail to meet the standard of care. Now, the requirements to prove medical malpractice are incredibly strict. You've got to prove 4 distinct elements: duty, breach of that duty, injury, and proximate causation. And proving that the standard of care was breached, that almost always requires expert testimony from other doctors in the exact same field. It's a really tough battle. Oh, and also, super relevant here, is the captain of the ship doctrine. This doctrine basically dictates that the lead surgeon is held legally responsible for the negligence of the other medical professionals assisting inside that operating room. The surgeon is the captain, and well, they take the blame if the ship sinks.
But there's a famous exception to needing that expert testimony, and this brilliantly illustrates how the law adapts to just basic common sense. It's called res ipsa loquitur. It translates to "the thing speaks for itself." If an injury is the kind that just does not ordinarily occur unless someone was negligent and the instrument was in the exclusive control of the doctor, the requirement for an expert is actually waived. The most terrifying plain English example of this, a surgical sponge left inside a patient's abdomen after surgery. Yikes, right? You really don't need another doctor to testify that leaving a sponge inside a human being is negligent. The thing literally speaks for itself.
Wow, we have covered immense ground today, from the basic philosophy of abuse of rights all the way to the operating table. But I want to leave you with this final, kind of provocative thought. Under Philippine law, the baseline standard of care to avoid being sued is just ordinary diligence, what the Civil Code beautifully calls the diligence of a good father of a family. So, where does that apply in your own daily interactions? How often are you truly observing it? I really encourage you to consider how this seemingly ordinary standard of care protects you and, frankly, exposes you every single day you step out your front door.
Thanks so much for joining me on this explainer, and hey, keep observing that diligence out there.